fatality reporting rule, as well as another proposed rule that would impact OSHA's record-keeping requirements. My name is Eric Conn. I'm a co-founder of the firm Conn Maciel Carey and chair of the firm's National OSHA Workplace Safety Practice Group. With me today is my partner, Amanda Strainis-Walker, also of the National OSHA Practice Group at Conn Maciel Carey. I'll go over a couple of logistics for this webinar. First, we are recording the event, and we will make a link to the recording available after the event is over, probably within a day or two afterwards, and we'll get that link out to everybody who participated. We'll also make the slides available to everybody who participated after the event as well. To cut down on background noise, we've had some problems with speakers and hold music and other things going on. We have muted all of the participant lines, but we do have this chat function down in the bottom left corner, and everybody's texting these days anyway. So please use that chat function to ask questions during the webinar. And then I think at the end of the webinar we'll try to open up audio if we can, but throughout the webinar we'll have access to that chat function. So if you have questions, comments, experiences you want to share that relate to this topic, please chime in, and we'll be sure to call it out so that everyone hears it, and we can address the question during the webinar. We'll tell a little bit about ourselves, and then we'll jump in and talk about the presentation. As I said, I'm chair of the OSHA practice group at Conn Maciel Carey. My practice focuses essentially exclusively on workplace safety and health law. I represent employers in inspections, investigations, and enforcement actions, primarily involving OSHA and federal OSHA-approved state OSHA programs, but other agencies, part of that federal alphabet soup as well, the U.S. Chemical Safety Board, the Mine Safety and Health Administration, and the Environmental Protection Agency. We work with employers and forensic experts to manage investigations of catastrophic incidents. And we work with employers to help manage the litigation of OSHA enforcement actions, appeals of citations, including cases that have been referred to the Department of Justice for criminal prosecution. We handle those litigation matters as well. We write and speak regularly on safety and health law issues like we're doing today. And we also work with our employer clients to help develop safety and health programs, to audit compliance with those programs, and to conduct training. I'm going to let my colleague Amanda introduce herself.
Hi, my name is Amanda Strainis-Walker, and I've worked with Eric for several years, and I got my start with regards to occupational safety and health issues at the Department of Labor, worked in the Assistant Secretary's office at OSHA for a couple of years before moving over to the Solicitor's office, where I also worked on safety and health issues. Like Eric, I represent employers exclusively at this point, and all aspects of safety and health issues, everything from compliance to enforcement to investigations, and that is my practice, and looking forward to talking to you today.
All right, so let's talk a little bit about what we're going to cover today. Primarily, this presentation is about a new final rule that has already been enacted and becomes effective at the beginning of the new year. So just a couple of weeks away, there is a new rule for what types of incidents and what types of injury events involving your employees have to be proactively reported to OSHA. So we're going to cover the details of that rule today, including the evolution of that rule, how we got to the types of incidents that we have to report today, where we were most recently, to give you some sort of sense of the, how this thing has evolved. We'll go through the details of the new rule, including down in the nitty-gritty of the definitions of the types of injuries that need to be reported, because it is not necessarily very intuitive. We'll also talk about the impact of the new reporting regulation on employers. And then finally, we're going to talk about a proposed rule. This injury and fatality reporting rule rolls up under OSHA's injury and illness record-keeping regulation, but it applies only to the reporting side of the record-keeping. We're also going to talk about another proposed rule that we have on pretty good authority that OSHA is going to push as hard as they can to implement before the end of this administration, and that is more on the record-keeping side, and specifically about injury and illness data that certain employers are going to be required to share proactively with OSHA. So there's a lot of new interaction with the agency with these proposed rules and the new final rule. So let's dig right into the new final rule. We look back sort of when the agency was born, there has always been a requirement for employers to report proactively to OSHA certain types of incidents. And originally, those incidents were incidents that involved a fatality to one of your employees and the hospitalization of 5 or more employees from the same incident. And you had 48 hours within which to report to OSHA that you had one of those types of incidents. And there were generally 2 methodologies for how you could report to OSHA. One was by telephone to the nearest area office, and then the other was by telegraph. So you know we're going back pretty far in time that we're talking about telegraph methodology. About 20 years later, OSHA updated its injury and illness record-keeping rule to affect what types of incidents needed to be reported, when, and how. And the new rule in 1994 still involved reporting a fatality, but it lowered the number of employees that were hospitalized in a single event from 5 to 3. So you now had to pick up the phone and contact OSHA within 8 hours instead of 48 hours to notify them of a fatality or what they called a catastrophe, which was defined then as a hospitalization of 3 or more employees. Going from 5 employees to 3 increased the number of incidents that had to be reported as hospitalizations, but it was still a pretty rare occurrence. And we track this data, and OSHA reports this data, and it's a pretty small number, generally ranging from about 10 to 25 a year, in which you have a single incident that results in the hospitalization of 3 or more employees. And it's not just hospitalization. We'll talk about this in detail about the new rule. It has always been some element of either overnight hospitalization, formal admission. We'll talk about the details of that. But it was fairly rare that those types of incidents occurred. Fatalities occurred on a higher rate, but the 3 hospitalizations did not. You had 8 hours, lowered from 48 hours, to make the report for either of these types of incidents to OSHA, and OSHA introduced a new methodology. You could still pick up the phone and call the nearest area office to report a fatality or the hospitalization or a catastrophe, but they also introduced a new 24-hour 1-800 hotline, and that, pardon me, tended to be the most common manner in which employers reported these types of incidents. It most often is you're getting a voicemail and leaving a recording about the type of incident that has prompted you to make this report. So now, 20 years later again, OSHA has looked at this and decided that there's not enough reports of incidents being made to OSHA. They feel like they're in the dark a little bit about the types of incidents and injuries that are happening out in America's workforces. So they have amended the rule again. This time, again, fatalities still required to be reported, and again, you're required to report them within 8 hours, so nothing has changed on the fatality front. But on what used to be the catastrophe front, that has been replaced with a serious injury. So a single employee hospitalized, formally admitted to the hospital for treatment, is required to be, you're required to notify OSHA. So rather than having, and then the other change here is they've added a couple different types of incidents, specific types of incidents, amputations and loss of an eye, that even if they did not result in hospitalization, a formal admission to a hospital, you still have to report those to OSHA. Fatalities still have to be reported within 8 hours, but hospitalization of a single employee, amputation, or loss of an eye have to be reported within 24 hours, so a new time period for these lesser but still serious injuries. The other, another interesting change with this new rule is the methodology for how employers can report these injuries to OSHA. You still have the telephone option, and that still includes calling the nearest area office or the 1-800 hotline, but they've also introduced, or will be introducing soon, a new technology for reporting to OSHA, basically a web-based portal where you can go to OSHA's website and type in the details of the injury report that you have to make to OSHA, hit submit, they get it electronically. I understand that that technology has not fully been developed by OSHA yet. They actually do not anticipate that it will be ready on January 1st, but it will be introduced as soon as it is ready. So let's talk about some of the more detailed, some of the more specifics around this rule. So on the next slide. So here we talk a little bit more about the detail of the rule itself. It was introduced or was finalized in September 11th of this year, 2014. It became a final rule, but it did not have an effective date until January 1st, 2015. And we'll talk about that, how that date might actually be a little bit different in state plan states and may even be delayed a little bit in federal states. And I'll tell you what information I have on that front. It introduced 5 major changes. I've talked about most of them already. You've got 24 hours to report inpatient hospitalization of a single employee, down from 3, a significant change. You've got 24 hours to report any amputation or loss of an eye, a new specific type of injury that has to be reported. And you have to report, the report may be completed via a new online portal, as we talked about. The next 2 items we haven't talked about yet, and at least item number 4 here is very significant. The idea here is that OSHA plans now to publish the data that employers report to OSHA about these injuries on OSHA's website. This fits in very well with a lot of the, if you've heard me speak before, you've probably heard me talk about OSHA's program of regulation by shaming. And a lot of people think that that's my jaded defense lawyer's term for that, but that's actually the term that OSHA uses itself for some of the programs they have where they publicize negative things about employers to try to influence their conduct, or more importantly, to influence other employers' conduct in the industry or generally in the country, because they see they don't want to be the next one to have this negative publicity. You see it in the context of enforcement press releases. You see it in the context of now this reporting serious injuries and fatalities on OSHA's website. And remember that you have to pick up the phone and call OSHA regardless of what caused that incident, regardless of whether it was gross employee misconduct, regardless of whether it was an act of God, defective product that you did not manufacture. It's a workplace injury. It's work-related. It's a new injury. You're required to report it to OSHA. They're going to put it up on the website with very little context, and it's not going to be helpful for any employer's reputation to have that data out there. One of the other changes that was included in this rule that has just become final is changing some of the low-hazard industries that are partially excluded from the record-keeping rule. I don't talk about that very much in this program, but if you have questions about that, let me know. We can get into that. The idea is all employers, regardless of whether you're partially exempt, regardless of size, and all those things, have the duty to pick up the phone and call OSHA to report these types of injuries. But if you are in a certain low-hazard industry identified by NAICS codes or SIC codes, now it's NAICS codes, you may be excluded from the record-keeping portion of OSHA's rule, keeping a 300 log and so forth. But regardless of your status as partially exempt, everyone is required to make these reports of injuries or fatalities. So let's go to the next slide and talk a little bit about the key time periods that are relevant in the new rule. We've talked a little bit about this, but there's nuance in here I want to make sure that everybody is catching. Important time periods. When you're talking about a fatality, you have 8 hours from when you learn about a fatality to report the fatality to OSHA. So if an employee is working on his own, he passes away at some point in the evening, but he's not discovered until the morning, you have 8 hours from when you discover this fatal injury to report it to OSHA. So the 8-hour clock is not about when the fatality occurs, it's when you learn about it. Likewise for the serious injuries, 24 hours from when you learn about a hospitalization, and this is where it gets really tricky, and we'll talk about this in the context of what hospitalization means, because that requires, quote-unquote, formal admission to the hospital for treatment, not for diagnostic testing, not for observation. So it's not clear to me when this 24-hour clock starts, and I've asked OSHA lots of questions, and it seems that it's not clear to them either. But the idea being you've got 24 hours from when you learn about a serious injury, and to me that would be 24 hours from when you learn that the employee is admitted to the hospital for medical care. And OSHA may disagree with that, and we're hoping to see some guidance from them about that. We're hoping to encourage them to adopt my interpretation, but they have not put out any clear guidance on that yet. But there is clearly 24 hours from when you learn. It's just not clear about what it is that you learn to start the clock. But then the other element to this that is really interesting is that a fatality is only reportable to OSHA if the fatal outcome occurs within 30 days of the incident. So if an employee is seriously injured and he's hospitalized and he's unconscious for 31 days and he passes away on the 32nd day, you do not have a duty to report to OSHA that a fatality has occurred. Now, the new change now is that a single inpatient hospitalization is reportable, so chances are if something is that serious that ultimately leads to a fatality, it probably has been a hospitalization that you were required to report to OSHA, and chances are they're going to be checking up with you about the ultimate outcome of that injury. Likewise, for hospitalizations of a single employee, it is only if the hospitalization occurs within 24 hours of the incident that it becomes a reportable incident. And again, this is a very, very interesting fact, an interesting bit of the regulation that I don't think OSHA has a clear sense of how it's going to be implemented. Because if an employee is seriously injured and he goes to the emergency room for treatment, that is not formal admission. And it's very clear that that's their focus is formal admission. Inpatient versus outpatient is the terminology that they have encouraged employers to look at for guidance here. Inpatient versus outpatient. And, emergency care in the emergency room is not inpatient care by just about every healthcare definition out there. So if the employee is treated and he's in the emergency room for more than 24 hours and on the 48th hour is transferred over to become an inpatient status at the hospital, did that hospitalization occur within 24 hours of the incident? I think it's a thin line to walk across. I'm not sure OSHA's interpretation. We're expecting guidance from them soon about these issues. I've asked lots of questions, and it's clear they don't know the answer to those questions. But the way I read the regulation, if the employee does not become inpatient, formally admitted, hospitalized for treatment within 24 hours of the incident, it's not a reportable hospitalization. OSHA may disagree with that, and hopefully we get some guidance soon, but that is my read of the regulation right now. Likewise, with amputations and loss of an eye, that those outcomes must occur within 24 hours of the incident for those injuries to be reportable to OSHA, except for medical amputations. And if an injury leads to later amputation, a decision by a healthcare professional that amputation is necessary, that is still required to be reported to OSHA, even if that happens more than 24 hours later. Let's go to the next slide and dig into this inpatient hospitalization issue a little bit more. Language of the new regulation says that a hospitalization is reportable to OSHA if it involves formal admission to the inpatient service of a hospital or clinic for care or treatment. So that does not include admission for observation or testing. It has to be inpatient admission for care or treatment. It no longer requires an overnight stay, but I think from a practical standpoint, the language doesn't say overnight stay anymore, but from a practical standpoint, because we are talking about formal admission to the inpatient service, it is hard to imagine a scenario where you have inpatient service that does not involve an overnight stay. So that may be nuance without effect. OSHA has acknowledged already, since the rule has come out, a great deal of confusion about the term admission, formal admission. Formal admission means something very different to different groups, to different entities, to different industries. It means something different to insurers, to hospitals, to patients, to the general public, just a general understanding of what that term means. And what they have told me is to focus not on the formal admission piece of this, but instead to focus on the inpatient language, and that inpatient and outpatient are more clearly understood medical terms, and that's the guidance that they're giving to folks. I think that's kind of irresponsible. The language formal admission is in the rule. If they did not intend for that to have meaning, if they did not intend for that to also influence what is a reportable hospitalization, it shouldn't have been in the rule. It should just say inpatient service for care or treatment. But it's there. But OSHA's guidance that we've gotten so far, informally, in phone calls with our contacts at the agency, is that OSHA generally is going to ignore formal admission and focus on inpatient hospitalization. So let's go to the next slide, and I'll tell you a little bit about this informal guidance I've been getting from OSHA. They are working on putting out formal guidance, and my expectation, although it's changing every day we get closer to Christmas and every day we get closer to the new year, is that they will put out some guidance before the new year, before the rule becomes effective. But we've not seen much. I mean, there is a page, they've got a fact page, but I don't think they've done enough to clarify this inpatient hospitalization term. Here's what they have told me. Again, they're going to focus on inpatient versus outpatient, which is a much more clearly understood term. And a representative at OSHA shared with me a couple of examples that, and this is a representative on the enforcement side responsible for this, for implementing this rule, gave two examples, both of which he said were not reportable injuries. And let's look at these and see if, based on our common understanding of the language of the regulation, whether we agree with that. I think it's useful guidance because I think it goes a little bit further than I expected. An employee breaks his leg. He goes to the emergency room. He's not formally admitted for inpatient care yet. He goes to the emergency room where his leg is set. He's administered prescription drugs to treat the pain, again, while he's in the emergency room before being released in outpatient context. That, I think we'd all look at that and clearly see that that's not a reportable injury in the context of this inpatient, formal admission inpatient language. The second example, I was a little surprised that OSHA takes the position as not reportable. So maybe they are a little bit closer to my view of this, of the rule. Again, an employee breaks his leg. He goes to the emergency room where his leg is set, but in the process of setting the leg and treating the injury, he begins to bleed out. The emergency room replenishes his blood while he's in the emergency room, before he's inpatient, before setting the leg. They go on to set the leg. They treat him with prescription drugs to treat for pain, and then he is sent to an inpatient admission from the emergency room to an inpatient ward where he is admitted for monitoring because he had a significant amount of blood loss. And since there is, since he's only been admitted for the purposes of monitoring, the representative from OSHA that I spoke to said that's not a reportable injury, because it doesn't matter that there was medical treatment at the hospital while he was not yet in inpatient care. Once he became inpatient, was he treated medically or just there for observation? And since he was just there for observation, that was not reportable to OSHA. Go on to the next slide and talk a little bit about amputations, which is one of the specific injuries that OSHA has now introduced as a type of injury that warrants a special reporting requirement. And Amanda insisted that we put this image on the slide. I apologize for its crude nature, but she insisted, and maybe I've got that wrong, but that's the story I'm going with. So we've got amputations, which is not a my original thought was, well, this shouldn't be very controversial. I think we have an understanding of what amputations are. But some of the nuance in the regulatory history and in the language of the standard and in some of the guidance that OSHA has put out, it actually has become a little bit, to me, not so clear-cut. So let's talk a little bit about the definitions of amputation. Traumatic loss of limb or appendage that has been severed, cut off, amputated, either completely or partially. When you get into the partial amputation, that's where things get confusing. Through regulatory history and guidance, it's clear that OSHA does not include avulsions, enucleations, deglovings, scalpings, and other types of severed ears, very interesting one to be excluded, or broken or chipped teeth. These are not amputations that require reporting to OSHA. Now, if they, independent of their nature of being an amputation, result in hospitalization for treatment, inpatient hospitalization for treatment, it would still be reportable, but here it's not reportable just as an amputation. Now, here's where it got confusing to me, because OSHA went on to say, so avulsions are not included as an amputation, but fingertip amputations with or without bone loss are reportable injuries. And I think, to me, that is very contradictory. I mean, a fingertip amputation with no bone loss, my understanding, is an avulsion. But OSHA is carving that out and saying, we want to know about those. And I think I understand the idea. You know, OSHA is incredibly focused on lockout, tagout, and machine guarding issues. They've got a amputations national emphasis program, and they are very much focused on those types of injuries. So I think they've included that because even if it's just a fingertip amputation, it's probably the result of the same type of operation that would result in a more severe amputation, and they want to know about that. They want to know where lockout tagout's not being followed and where machine guarding is not being followed. The rule for amputations also includes medical amputations resulting from irreparable damage. The next slide talks just generally about the types of injuries that need not be reported, and they roll up into some of the categories we've already talked about, but I've put it all together here in one place so you know the types of injuries that are not reported. First, and we haven't talked about this, is fatalities or injuries that result from a motor vehicle accident on a public road. So there's an exception for that if you are in the construction industry and your employees are working on the public road. That is their construction site, and they are injured by an automobile, whether it's another construction vehicle or a public vehicle. That is reportable, but only in the construction context. Everybody else, you don't have to report motor vehicle accidents on public roads. If it's a motor vehicle accident on your property at your workplace, that is reportable. Fatalities or injuries that occur on commercial or public transportation systems also do not have to be reported to OSHA. So if someone is injured, even if it's business travel, but they're injured on an airplane, a subway, a bus, train, other public transit system, that is not reportable to OSHA. Likewise, it is not reportable to OSHA if the inpatient hospitalization or the component of an employee's visit to the hospital that is inpatient is only for diagnostic testing or observation. That is not a reportable injury. And then likewise, just as a basic matter, outpatient care or care given in a hospital when the employee is not formally admitted as inpatient. So as long as you're not inpatient, even if you're getting substantial medical care, that is not a reportable injury. So on the next slide, we talk a little bit about the type of information, the specific information employers are required to share with OSHA when they pick up the phone or if they use this web-based portal to make a report. And this really hasn't changed from the old rule, but now that there is this web-based portal and you may be typing your reports, it's important to understand what you're required to share. And that includes an establishment name, the name of the employer, the name of the workplace where the injury occurred, the location of the work-related incident. And I think of that sort of as the same context of your record-keeping logs. It's not the facility address, but it's the location within the workplace where the incident occurred, the loading dock, machine shop, so forth. You're required to identify in your report to OSHA the type of reportable event, whether it's a fatality, an inpatient hospitalization, an amputation, or a loss of an eye. What is the reason you've had to pick up the phone to call OSHA? You need to identify that. And you also need to identify the number of employees who suffered the consequence that caused you to pick up the phone. You also have to identify the names of the employees who suffered the event. And this is, to me, getting into a somewhat controversial issue where OSHA is talking about publishing on their website data from employers' injury reports. They've indicated that they're going to scrub private information, health information about the employee, but I'm not sure they have the capacity to do that, and I worry about their ability to protect that data. So there is a scenario here where they're publishing data, but they're collecting a lot of data that I would be very uncomfortable seeing published. You're also required to share with OSHA a contact person with the company, whoever it is that OSHA should interact with if they decide to start an inspection, if they decide to ask questions about the incident, who should they be interacting with at the company. And finally, provide a brief description of the work-related incident. Talk a little bit about the context of this web portal reporting, how careful we want to be with this brief description, and emphasize on the word brief and understanding that these reports are made very shortly after an incident where you may not have all the information you need to give a full and proper report, and you want to be careful to not speculate and share information before you really know what's going on. On the next slide, this is David Michaels, the chairman of OSHA, the head of the Assistant Secretary of Labor for OSHA, the head of the agency, talking about what he thinks the impact of the rule is, OSHA's purpose for implementing the rule. says that OSHA will now receive crucial reports of fatalities and severe work-related injuries and illnesses that will significantly enhance OSHA's ability to target our resources to save lives and prevent further injury. The idea here is, Michaels is just saying, we're doing this so that we can determine where to target our resources. More reports of injuries, more inspections, more incident inspections. So this is their targeting of resources that will follow. On the next slide, we talk a little bit about sort of my take on the impact of this rule. First of all, it's effective January 1st, 2015. That's coming up in 2 weeks. I think OSHA has not done a great job of getting the word out about this rule, and they recognize that. I think they are aware that a lot of employers don't know about the rule, don't know the details of the rule, and there's a lot of unanswered questions about the rule. So I have heard some mumblings from within the agency, and do not take this as legal advice, do not take this as a fact that you will rely on, but I have heard that there is some indication that OSHA may defer enforcement of the rule for some period of time to allow more employers to become aware of the new requirement. So I think you are aware of the requirement. You should be making these reports starting January 1st, unless there is something public put out by OSHA that says it's not required. But my understanding is that they may exercise their enforcement discretion to not issue citations about failures to comply with this for several months after the effective date, because there's so many questions about it. But we don't know that to be the case yet, and I will update if I see something more about that. Another interesting element about the effective date is that state plans, state OSHA programs, about half the states in the country have their own OSHA program. They are required to adopt this rule, but they are not necessarily required to implement it January 1st, 2015. Federal OSHA recognized that this was in the works for federal OSHA for longer than it will have been for the states, who saw that it became a final rule in September like everybody else, and they need more time to implement changes to notify their industry communities about the new requirement. So if you operate in a state plan state and you have a question about what the effective date is for this requirement in your state, send us a note, give us a call after this meeting, whatever, and we will let you know. We've got the answer to probably about half the states we already know the answer to, and we can get it pretty easily for the others. Real impact to me, though, of this rule is a dramatic increase in the number of reports to OSHA. As I said in the very beginning, it was extremely rare that you had a single incident that resulted in inpatient hospitalization of 3 or more employees or 5 or more employees. Even when it was lowered to 3, you saw maybe a dozen to 25 or so a year. Now that we're talking about hospitalization of a single employee, OSHA projects, and depending on what the definition of hospitalization is, it's not clear to me, but OSHA has projected an increase of about 25,000 more reports to OSHA. Federal OSHA conducts about 40,000 inspections a year, and now we're going to have employers picking up the phone 25,000 times more often to call OSHA. That's a huge chunk of what I expect to be some diverted enforcement resources to more incident inspections. And another data point that I think is interesting to think about in this context is that if OSHA visits your site, the national average across all industries, across all inspection types, whatever caused OSHA to come in and visit your facility, they issue at least one citation in 75% of the inspections they conduct. 76% actually. So here you're talking about more reports to OSHA, going to be more inspections, and when there's more inspections, there's certainly going to be more citations arising out of these types of incidents. Then the other major element, other major impact of this rule is the expansion of OSHA's public shaming campaign, putting up on OSHA's website employer's name and numbers of serious injuries and fatalities, specific details around injuries and fatalities. A big deal. This is all going to be publicized out of context, without any indication of whether the employer's safety program or the employer's equipment had anything to do with the injury. I think that's an unfortunate use of OSHA's authority. The next slide, I think this is the last thing I'm going to talk about before I turn it over to Amanda, and that is the online reporting option. I think where OSHA got this idea, if you go to OSHA's website or if you've gone to OSHA's website anytime in the last few months, you will see the first thing right there on the home page, and big picture and big links and big letters, is talk about how employees can file whistleblower complaints against their employers for safety issues. And they introduced a new web-based portal for employees to more user-friendly, much more easily get on the computer and make a complaint to OSHA. And OSHA saw a big spike in employee complaints and whistleblower complaints in connection with that new web-based portal. So they're very excited about the technology. I think they're trying to now roll it out on the employer side. Maybe employers will take advantage of this as well. I have some real concerns about this technology. We've talked a little bit about the security risks. There's private employee information, health information about employees. I'm less trustful that the federal government is able to protect that data, has the capacity to scrub that data before they publish it on their website. That makes me a little bit nervous. But more important than that is I don't like the idea of committing in writing to a version of this incident within 8 hours of a fatality or 24 hours of a serious incident. There's just no way to know what really happened. You're going to do an incident investigation. You're going to get to the bottom of it, and I think it's just too early to commit in writing to a version of this story that has the potential to be used against you. Anything that you put in writing to OSHA and hit submit, it goes into their database. It can be used against you in a later enforcement action by OSHA. It can be used against you. Plaintiffs' attorneys, employees can access this information by FOIA and use it against you in civil litigation. It can be used against you by the media. They get access to it by FOIA, and they use it to write some nasty story about you. And be used by unions. We've seen a couple of major new decisions by the National Labor Relations Board that we expect to ramp up organizing campaigns by unions. This would be another tool for them to use to wave around to your employees and say, you need us in here. Your employer doesn't care about you. Look at these terrible injuries they're allowing to happen. You need us to protect your rights and to protect your safety. So I just am uncomfortable putting something in writing this early. My strong preference is the telephone option, and my even strongest preference is to use the telephone option where you actually speak to somebody. They're going to take their notes, but that's all they are, is their notes. Even if you're leaving a voicemail, there's a recording of what you've had to say, effectively the same thing. But if you're on the phone with somebody, you give your version, very, very minimal, very brief. I would even think about this in the context of your 300 log, that same very brief description of the injury that you put on the 300 log. You should really not be going much beyond that when you talk to employers or when you talk to OSHA about injuries. So that's my portion of the discussion on this new rule that becomes effective January 1st. Has anybody typed in any questions, or if you have any questions about that rule, type them in and we can tackle those. And then after that, we can jump into the other proposed record-keeping rule that I think is also going to be very impactful.
I see. It doesn't look like we've gotten any questions at this point, so I'm just going to go ahead and jump in with regards to the proposed rule. Good afternoon. This is Amanda Walker, and I'm going to be following up with regards to the regulations that Eric just talked about. As though they're not enough, OSHA is proposing more record-keeping regulations. OSHA is proposing additional changes to the record-keeping requirements that are likely to be implemented before an administration change. OSHA staff have identified this rulemaking and these additional record-keeping changes as a top priority to finalize before January of 2017. And just to emphasize that, there was a documentation and news publication that came out this morning with Jordan Barab highlighting this rulemaking as one of the top priorities that is on their slate to get completed before this administration changes. So it's been on the radar screen for them, and they continue to stress the importance of it. So what are these additional changes? In addition to broadening the scope of workplace incidents that employees will have to report that Eric just talked about, OSHA is seeking to have more direct and immediate access to employee record-keeping documentation. The current regulation requires most employers to fill out 3 forms. probably most of you guys are familiar with these forms. The first one's the OSHA log. It's a 300 form. Then there's the incident summary, which is a little bit more detailed, has the employee's name on it, sometimes their address, the number of years they've worked at the firm, and their position. That's called the 301. And then an annual summary, which is the 300A, that is filled out, includes the number of hours that are worked, employees work in the workplace, and it's required to be posted in the workplace on an annual basis. Employers usually fill out these documents, post the annual summary as they're required, take it down after a couple of months, and then file everything in a drawer for 5 years, which is the time period required by the regulations. Now OSHA is proposing a requirement that will require employers, most employers, to file these forms electronically on a regular basis. There's two different time frames. Employees OSHA is dividing up different employer groups by the number of employees. The employers with more than 250 employees will have to do a quarterly submission of all forms. So that would be the 300 log, the 301, and then, of course, you'd only be under a requirement to do the annual summary one time, but the other forms would be submitted 4 times throughout the year. And then for employers with between 20 and 200 or 249 employees in high emphasis or high hazard industries, which OSHA really hasn't clearly identified at this point. They might be using some language from their national emphasis program. They want those employers to submit the annual summary on an annual basis. The reason that OSHA says that they want this additional information is kind of a moving target. When OSHA first came out with this proposed rule in 2013, they said that they would like to have better access to more current data. Currently, OSHA collects data through their OSHA Data Initiative as well as some additional documentation from BLS, and this is a paper process. Some of you employers might have received a letter request in the mail from OSHA or BLS asking for information that's included on your annual summary. And you mail it back in, the data is compiled, and by the time OSHA has access to this information, it's usually 3 to 4 years old. OSHA says that the data lag prevents it from picking up and reacting to workplace safety and health trends. And that's what their justification for this change was when they first proposed it. They're kind of backing away from that at this point since they received so many comments and concerns from trade associations and employers in the community. They're now saying that the change is necessary to compile data for research purposes and to facilitate more transparency. It seems as though OSHA is kind of backing away about their direct access to the data and how it would be used, but I still think that they have every intention of using it to pick up on trends and to react and to incorporate it into their site target SST program, which is their site-specific targeting for employers that have high injury and illness rates. Moving on to the next slide. Either way, we know the proposed rule will require submissions electronically. Just as a note, OSHA doesn't have a great track record when it comes to technology. I know of one particular technology update that dealt with enforcement data that went over a couple of years, a handful of years, maybe even 5 years over its projected completion date, and who knows how much money. So that the idea that they're going to be able to put together a pretty secure or quote-unquote secure website that employers can submit their data on the turn of a dime as soon as something's implemented with regards to this is questionable and should definitely raise some concerns with regards to how secure it's going to be. They also plan on publicizing the employer, making this information publicly available. There will be no context with regards to the injuries, no mention if it was related to employee misconduct, if there was a breakdown in procedures, if the employee didn't follow procedures. So there will not be any context with regards to the injuries on the forms that will be publicly available. And individuals seeking this information will be able to put their own interpretation with each individual injury. The comments for this portion, this proposal came out on November 7th, 2013, and the comment period closed in March 8th, 2014. That was after an extension. This rulemaking attracted a lot of attention. A number, I've heard maybe it's one of the most voluminous rulemaking documents that OSHA's experienced recently. Quite a few comments, a lot of letters from individual companies were included in there. And as we'll talk about in a minute, OSHA reopened the rulemaking docket to get some additional information based on the initial comments submitted. Either way, we know that the amount of information that's going to be collected under this new proposed rule is voluminous. Basically, we're looking at OSHA will have access to about triple the amount of information that they currently receive through their OSHA Data Initiative and BLS information. Basically, be sitting on a mountain of data. And the big question is, what are they going to do with it? There's not a set of employees within OSHA's national office ready to crunch numbers and sort out this data and to best make use of it. Really trying to figure out how the agency is going to be using it. It's not clear, and what value it will provide to the agency, which has been an ongoing concern voiced in the rulemaking. Moving on to the next slide, like we mentioned, a variety of comments were submitted during the rulemaking process that closed in the spring. Our firm submitted some comments, and these were some of the points that were made. One of the biggest one was, what's the gap that OSHA is trying to fill with this proposed rule? What's broken with the current system of receiving the data? It might be a little bit of a lag time, but we are seeing, and even OSHA admits that injury and illness rates are going down, the number of fatalities are going down, so it doesn't really seem like we have a broken system here. Why is it that we need to change the way the data collection is done? Another issue that was developed, or a lot of commenters submitted, is concerns with regards to the risk of underreporting of injuries that would be caused by making this information publicly available, and would not have all the information on the injury and illness log. This has been an ongoing concern of this administration, and they certainly focused on this in their reopening of the document. As Eric mentioned earlier, this data could also be used for union organizing, to get unions into new facilities. So that's another concern. And then it undermines the original intention of the record-keeping policy. It's a no-fault system. So that would also be another drawback. And another thing, OSHA substantially underestimated the financial burdens. I think for employers with over 250 employees, they estimated that it would be roughly $180 for those employers to comply with this rule versus $8 for the employees that have more than 20 employees but below 249. So those are some issues that we had identified in comments submitted during the comment period that ended last spring. As a result of all the comments that OSHA received, they did open the proposed rule for additional comments, although they were very focused on one particular issue, and that was the idea that this could cause underreporting of injuries. They were looking for precise information, examples to get documentation how this would impact or cause employees to underreport injuries. They were very interested in that, and that was the primary focus of this new comment period, which just ended in October. Another inclusion in the reopened docket had to do with language that would require employers to inform employees of their right to report injuries and illnesses. Right now, there's a requirement that employees have to inform employees of their right to report or identify safety and health concern. So this would broaden that notification requirement. There was also some discussion of limitations on making the requirements to be not burdensome, basically limiting drug testing. If employers require an injured employee to have drug testing after each injury, that could potentially be an issue in noncompliant with OSHA requirements. That solicited a lot of feedback from trade associations and employers in this second docket or comment period. There was also time frames which employers had to report an incident And one of the most substantive was adding a new clause of protections to employees, protecting them from any adverse action that an employer could change their hours or change their job position with regards to reporting an injury and illness. And this seemed to be duplicative with the already existing provisions in the OSHA standard that protects employees from discrimination. And that is basically, in a nutshell, what OSHA is proposing. As I mentioned, the most recent comment period has closed, and we're currently waiting to see where OSHA goes with this next. Probably the next step at this point would be a final rule, which I don't know that we'll see it in 2015. 2016 might be a possibility, but certainly anxious to see what OSHA decides to do with all the comments that are in the docket. And it's a good possibility that it will be legally challenged before everything is finalized with regards to it. That is my portion of the presentation, and we can open it up to questions. I don't know if any more have come in during this time, but happy to entertain them. And then also, if you'd like to submit them to us afterwards via email, our email is on the last screen, and we'd be happy to answer those questions. That will conclude our presentation for today. Thank you.